A very warm welcome to all of you present and a very good afternoon. So today we present before you the thorough newspaper analysis for the 6th and 7th of March 2024. So let's proceed further and have a look at the agenda for today. Now, first of all, for our editorial segment, we've taken up a Supreme Court verdict which pertains to a criteria which the court saw in the state of Rajasthan and which is also present in a lot of other states, wherein a candidate he was disqualified from submitting his application or from asking that he be considered as eligible for a particular post on the ground that he has more than two children. So the title of this article is Supreme Court upholds Rajasthan rule barring those with more than two children from police service. So what is the case? This judgment or verdict, it essentially came in the last week of February. And today we discuss in this article as to, what this particular case was, what is that impugned provision of that rule, and also we have a look at one of the landmark judgments on this entire matter only, which go back to 2003. And lastly, we have a look at, what are some of the other similar provisions in various states, the aim of which is to address the concern of increase in population and the government's encouragement for family planning. Now, secondly, we talk about important news updates. And this is going to be followed by the last segment for today, which is the segment for legal news updates. So let's now start with the article without further ado. Okay, so let's see the context of this article, and the heading of which is Supreme Court upholds Rajasthan rule barring those with more than two kids or children from police service. What is the case? Let's see the context of this entire matter. So the Supreme Court has affirmed the Rajasthan government's decision to bar a candidate or bar candidates with more than two children from applying for a police constable post. A bench of Justices Surya Kant, Dipankar Datta and K.V. Vishwanathan ruled that Rule 24, Sub-Rule 4 of the Rajasthan Police Subordinate Service Rules of 1989, which stipulates a maximum limit of two children per candidate, it is non-discriminatory and is constitutional. So essentially, before the court, there is this one rule of the Rajasthan Police Subordinate Service Rules of 1989, which was challenged. What is that rule? The rule is Rule 24, Sub-Rule 4. What does this rule say? It essentially stipulates, it provides that a candidate who has more than two children is not eligible, is debarred from being considered as eligible for this particular post, which is concerned here. Now, the Supreme Court, in its verdict, has stated that no, this is not discriminatory. We cannot say that this particular provision is discriminatory or ultra viols the Constitution. It is very much within the bounds of the constitutional limits. This is what the Supreme Court has held. So now let's have an idea of what do the 1989 rules they say, as in what are some of the other provisions of this rule, what is the policy behind this rule, what is the intent of the legislature that it seeks to achieve by enactment of this particular rule. So the Rajasthan Police Subordinate Service Rules of 1989, it applied to the entire police department in the state of Rajasthan. So you know how there are different law enforcement agencies in a state. So this particular piece of legislation or the rules, they apply across all different various units. So there is a rule, which is Rule 2J in these rules, which define the term police establishment. And as per that definition, it includes every department, be it, the police department, the anti-corruption department, and other such units as are specified by the Director General cum Inspector General of Police from time to time. So the Director General cum Inspector General of Police has been given the authority that, we are an order or so on and so forth. You can say that such and such unit of law enforcement agencies is going to come within the ambit of the term police establishment. So then that would be included here. So from this paragraph, what we need to notice that these rules, they apply across entire police establishment in the state of Rajasthan. Secondly, broadly, Rule 24, which is the rule concerned here, it deals with disqualification for appointment, and it is prescribed certain grounds for appointments. So apart from those with over 2 children on and after 1st June 2002, it also disqualifies male candidates with more than one living wife, unless the government is, given certain satisfactory grounds, that there are special grounds existing under which I can have more than one wife or more than one living spouse. The male candidate can contend so similarly, female candidates who are married to those who already have a living wife, they are also disqualified unless again they furnish some special grounds for justifying such sort of an arrangement. So also, candidates who are accepting dowry, they are also treated to be disqualified. So candidates who are accepting dowry at the time of marriage, they have been disqualified as well. So what do we concur from this paragraph is that there are a couple of grounds on which candidate is deemed to be disqualified. So one of the ground being that if you have more than 2 children on and after this particular date, which is 1st of June 2002. So after this benchmark date, if you have more than 2 children, then you are disqualified. Secondly, if you have a living spouse existing, if you're a male candidate, so you have more than one wife, and if you are a female candidate married to such husband, such man, or so, then that would be a ground for your disqualification. And accepting dowry at the time of your marriage is also another ground for disqualification. Further, we need to note that while accepting or demanding a dowry, it is illegal. Having more than a certain number of children, it has not been declared a crime in the statute book. It is certainly a ground of disqualification, but it has not been declared a crime in the statute books. However, both the center and the state governments, they have made multiple attempts to push the population towards the two-child policy. In this particular case, the court was dealing with Rule 24, Sub-Rule 4, that we've already seen, of the Rajasthan Police Subordinate Service Rules of 1989. This rule essentially says that no candidate shall be eligible for appointment to the service who has more than 2 children on and after this benchmark date. So what is that date? It is 1st of June 2002. This is the concerned provision. Now, there are two conditions in order to attract this disqualification. So what are those two conditions? First is the benchmark date of June 1st, 2002. So the first condition is that the candidates having more than 2 children will not be deemed disqualified as long as the number of children they had on 1st of June 2002 does not increase. Secondly, this is also interesting. Let's say a candidate had one child in the first pregnancy. In the second pregnancy, the candidate has twins. So now here, the number of children comes out to be 3, which is more than 2. But the pregnancies leading to the birth of these 3 children is 2 in number. So here, such candidate is also not disqualified. So secondly, for candidates having only one child from earlier delivery, but more than one child from a single subsequent delivery, that is to say, if twins are given birth, then the children so born shall be deemed to be one entity, and therefore such candidate would be considered to be eligible. So that's about the provision. Now, let's see what was the case essentially, as in who was the person concerned, and did he approach the High Court first? And if yes, what did the High Court say? And then how did he come to the Supreme Court? So here, please note The court was acting on an ex-serviceman's plea after retiring from defense service in nearly 2017. He wanted to serve in the Rajasthan police and he applied for the post of constable there. Now, because he had more than two children after 1st of June 2002, which is the benchmark date, so he was, termed as disqualified. Now he felt aggrieved. As a result, he approached the Rajasthan High Court. Before the Rajasthan High Court, again, his contention was the same, that it is discriminatory. However, the Rajasthan High Court did not agree to it, and the Rajasthan High Court said that this is not discriminatory, and therefore the matter reached the Honorable Apex Court. Now, before the Supreme Court, in its order which is dated February 20th, the Supreme Court dismissed the candidates' challenge to the Rajasthan High Court order, recalling that a somewhat similar provision, it was introduced as an eligibility condition to contest panchayat elections, and it was in fact upheld by the Supreme Court way back in 2003 in the case of Javed versus State of Haryana. The court upheld the impugned rule. So this is very important. This case, it is often times asked in our preliminary exams also in a couple of judiciaries. So first, for exam perspective, please note down the name of this case, which is what? Javed versus State of Haryana. What is the ratio of this case? So essentially here what happened, that in the state of Haryana, it was stated to be a condition that if you want to contest the panchayat elections, you should not have more than two children. Here, in the case of Javed versus State of Haryana, the Supreme Court back in the day noted that this was not, no, discriminatory or ultra vires the constitution. Why? Because it had a legitimate object behind it. What was the legitimate object? The policy of population control. So this is the next segment where we talk about what was the ratio of the case of Javed versus Haryana. So please note down that in the present case, the Supreme Court placed reliance on the 2003 ruling and reiterated the same in essence. So in the case of Javed versus State of Haryana, a three-judge bench of the Supreme Court upheld an act which is called the Haryana Municipal Second Amendment Act of 1994 and consequently affirmed the two-child policy for holding the office of Sarpanch or Up Sarpanch in the state of Haryana. The bench back in the day held that the classification which disqualifies candidates for having more than two living children, it was non-discriminatory and it was intra-vires the constitution, not ultra-vires the constitution. And again, why? Because there is a legitimate object behind this provision and it was to promote family planning. Now, let's see, this is an important segment. Let's say if you were to ask to write an essay in your exam, something to do with population control or your views and opinion, maybe you can substantiate your answer with citing all of these statutes that we see in various states. Now, before we look at the example of such policies in different states, let's see whether this particular subject of family planning, it is a subject or entry in the union list, is it an entry in the state list or in the concurrent list? Because accordingly, we see who is the concerned authority to make laws. So population control and family planning, it is a subject on the concurrent list, which contains matters both on which the center and the state can legislate. So therefore, exercising power which is available with the state lawmakers, several states, they've included a small family as a criteria to qualify for various positions. Now, in this background and light, let's see example of some of these policies. Okay, so first we talk about the state of Rajasthan. The Rajasthan Panchayati Raj Act of 1994 disqualifies those with over two children from contesting elections such as the election of a panch or a member. Similarly, we have the Odisha Zilla Parishad Act of 1991. It again bars those with more than two children from contesting the election at the lower these tier elections. Thirdly, we have an example coming from the state of Gujarat. So, the Gujarat Local Authorities Laws Amendment Act of 1962 disqualifies those with more than two children from contesting elections for bodies of local self governance like panchayats, municipalities, and municipal corporations. So far, what can we infer from these three examples is mostly all of these laws they deal with elections to panchayat and the local self governance institutions, panchayats, zilla parishads. While similar laws exist for local body elections in states like Maharashtra, Assam, Telangana, and Andhra Pradesh, some of these states they've gone a step further, bringing such two-child policies into the realm of public employment as well. So these were with respect to panchayat elections. Some states have brought these rules in the realm of public employment as well. So, for instance, if we take an example of the state of Maharashtra, here there are rules called the Maharashtra Civil Services Declaration of Small Family Rules. They came into force in the year 2005 and they mandated the filing of or the filling of a small family declaration while a candidate applies for a government job. In 2021, the UP State Law Commission it proposed the Uttar Pradesh Population Control, Stabilization and Welfare Bill, which sought disqualifications from appointment for government employees with more than two children, disqualifying those with over two children from contesting municipal and panchayat elections, and a housing tax rebate for non-government employees having two or fewer children, among other incentives. So the proposed law here in UP, it has fold bifurcations. So it is applying to those who are seeking public or government employments, and also to the elections in panchayats and the tier self-government institutional levels, and also some benefits and incentives are given to those with smaller families. I hope this article serves helpful and it is useful for your exams. And now we proceed to the next segment for today. So now we proceed to the national news update for today. And here the first update is this. In all of these scheme related or some launch related updates, for our purpose, which is, the exam pointers, we have to note just 2-3 couple of things, So here, let's see. The Ministry of Defense, it has announced the creation of a corpus of rupees 750 crore under the Aditi Scheme. What is the Aditi Scheme? It is acing development of innovative technologies with IDEX. What is its purpose? It is to promote innovations in critical and strategic defense technologies. Also, startups under the Aditi Scheme, they are eligible to receive grant in aid of up to rupees 25 crore for their research, development and innovation and all of those functions. Now moving on, this is also an important update. The Union Minister of Steel, he has inaugurated India's first green hydrogen plant in the industry or sector of stainless steel. The Union Minister concerned, he virtually inaugurated India's first green hydrogen plant in stainless steel sector. Where is the location, which is important for exam perspective? It is at Jindal Stainless Limited in Hisar, Haryana. Let's note 2 pointers also. It will be the world's first off-grid green hydrogen plant for the sector or industry of stainless steel, and also world's first green hydrogen plant with rooftop and floating solar. Moving on. So this is an important update and it concerns all of us, the citizen, people like you and I, because nowadays we are seeing that online scams and, a lot of fraudulent calls via SMSs, calls and, WhatsApp texts. they're very prominent these days. So in order to address that, this is an important launch. So the Department of Telecom, it has introduced two technology initiatives to strengthen efforts in combating mobile-based scams. The Telecom Minister, Ashwini Vaishnav, he announced the launch of CHAKSU. What is the name of this platform? It is CHAKSU platform. What is the purpose? To enable people like you and I to report suspected fraudulent communications from mobile numbers via calls, SMS, WhatsApp, text, and all of those. Another important feature is that the government has launched a new digital intelligence platform. What is the purpose of this platform? It will allow all of these entities. What are the entities? Banks, payment wallets, social media giants, telecom service providers to share data regarding suspected fraudulent connections on a unified single space. So this is also important. Please note down CHAKSU platform, new digital intelligence platform, which serves as a unified single space where all of these entities can share data regarding fraudulent connections. Moving on, this is in the sports segment for today. Sai Praneeth, he retires from badminton and he is all set to coach in US from next month. Sai Praneeth, he announced his retirement from international badminton after a 24-year-long career, which saw him win a World Championship bronze medal and represent India at the Tokyo 2020 Olympics. We'll further see his career briefly, but what we need to note down is he is an international badminton player. He is now announced his retirement after a long-serving and a very, very sound career of 24 years. And post his retirement, he will begin his new innings as the head coach of the Triangle Badminton Academy in the US. Let's see his career wins first. So the shuttler, he has won 2 bronze medals in the men's team events at the Asia Team Champions in 2016 and 2020. He won 3 BWF titles in his career, the Canada Open in 2016, Singapore Open and Thailand Open in 2017, all in men's single category. He was felicitated with the Arjun Award in the year 2019. So this is something that you may make a note of it. This is also important update. So Prime Minister of India, he has inaugurated India's first underwater metro in Kolkata. Prime Minister Narendra Modi, he has inaugurated India's first underwater metro line in Kolkata. He has virtually inaugurated several other metro services across the country. Let's note down some pointers of this metro line. So the Howrah Maidan Esplanade section underwater metro line, it has the first transportation tunnel under a river in India. So the first transportation tunnel under a river in India is here, and the station, please note down, it is the marking, which is Howrah Maidan to Esplanade. It passes under the Hooghly River, Kolkata and Howrah, and are situated on its east and west banks. This is something that you may make a note of, but this is not important for your exam perspective. Moving on, this is important. So recently, the state of UP, it has become the first state to issue 5 crore Ayushman cards. The UP government or the state of UP, it has become the first state in the country to issue 5 crore cards under the Ayushman Bharat scheme, providing health insurance. The state also maintains the leading position, the top position, in terms of the highest number of such cards issued compared to the other states. There has been a noticeable increase in the number of patients who are receiving free treatment under the scheme daily. Next up, we have another important update which is beneficial for the farmers of our nation. Government launches gateway to facilitate post-harvest financing for farmers. What is post-harvest financing? Let's see. So the government has launched an online digital platform. What is the name of this platform? Important. So it is E-Upaj Kisan Nidhi. E-Upaj Kisan Nidhi. This is the name of the platform. The purpose of it is to empower farmers with access to pledge finance against harvested commodities. So essentially, what the farmers can do is they can store their agricultural produce, the post-harvest commodities produce with the Warehousing Development and Regulatory Authority. And by pledging the post-harvest product, it can secure post-harvest loans from banks. The digital gateway, it verifies farmers' details through an integrated database comprising the UIDAI, the Central Board of Direct Taxes, repositories, and the CIBIL score. So this is not needed. Just remember the name, which is E-Upaj Kisan Nidhi. Purpose is to enable farmers that they can pledge their post-harvest products and commodities at or with the warehousing development and regulatory authority. They can keep it or store it there and thereafter take loans from banks on that. Now we come to the international segment, and both of these are important updates. So Nepal Prime Minister, he forges new alliance with ex-premier's party after splitting with Nepali Congress. So please understand, until now, what was the political dynamic? So Prime Minister, he had an alliance government formed with Nepali Congress. But owing to certain political differences in the top leadership of these two parties, now the Prime Minister-led party has decided to split the alliance and form a new alliance with another political party, which involves the former Premier of Nepal. So let's now see. Nepal's Prime Minister Pushpa Kamal Dahal Prachanda, he has decided to form a new alliance with former Premier KP Sharma Oli's party after terminating its nearly 15-month partnership with the Nepali Congress owing to certain differences. So what were these two parties which had formed the government until now? So the alliance was between two political parties. The Communist Party of Nepal, led by the Prime Minister, and the Sher Bahadur Dioba-led Nepali Congress. Nepali Congress led by Sher Bahadur and the Communist Party of Nepal led by the Prime Minister. They had the alliance. The alliance is now announced to be terminated, and the new alliance is in the process of being formed with the ex-premier of Nepal. Prachand, he became the Prime Minister for the third term with the support of the Nepali Congress back in December of 2022. Next update comes from France. This is also very, very important. So, France makes abortion a constitutional right. France has become the first country in the world to explicitly include the right to abortion in its constitution. Parliamentarians voted to revise the country's 1958 constitution to enshrine women's guaranteed freedom to abort. Abortion has been legal in France since the year 1975, but as per the polls, they show that around 85% of the public supported amending the constitution to protect the right to end a pregnancy. So this amendment, it becomes the 25th amendment to modern France's founding document and the first since the year 2008. So pointers to be remembered for exam is which country has done this. So your answer should be France. All right, so this has brought us to the legal development or legal update segment for today. And here we have 4 updates, I believe. And the first one is from the Honorable Apex Court. So let's dive into it. The Supreme Court, it has recently observed that the evidence which was not a part of the pleadings the evidence which is not a part of the pleadings of the parties, it couldn't be led in the trial. Let's see the background of this case. So in this case, the Supreme Court essentially was dealing with a civil appeal. Appeal was against what? This appeal was against the decision of the High Court. What did the High Court say, which is impugned as and assailed before the Supreme Court? It is the High Court had considered the evidence which was not pleaded in the pleadings of the plaintiff. So High Court considered certain piece of evidence which was not pleaded in the pleadings of the plaintiff. And therefore, the defendant felt aggrieved and he approached the Supreme Court in a civil appeal. So the Supreme Court held that there is no quarrel with the proposition of law. The court has categorically held that the proposition of law is very well settled, that no evidence could be led beyond pleadings. So the name of this particular case is Srinivas Raghavendra Rao Desai, dead and now represented by the legal representatives, versus V. Kumar Vaman Rao, alias aka Alok and others. Next up, we have an update from the Supreme Court itself. Test applied under section 319 of the CRPC. It is more than prima facie standard. So what does this update mean? Before that, let's see what is section 319 of the CRPC. So this section, it confers power on the court to proceed against persons other than those who are named as accused in the charge sheet but appearing to be guilty of the offense. So the trial is going on, and let's say there is an XYZ person. He is not named and identified as an accused in the charge sheet, but during the proceedings, his name come up, let's say, in the testimony of any witness, and he now appears to be involved. So then the court has power, the trial, to proceed against such persons. This is the crux of section 319 of the CRPC. So now Supreme Court has reiterated that while allowing an application under section 319 of the CRPC, so usually it so happens that the prosecution often files these applications saying that you rope in such and such person who was not identified in the charge sheet. So you bring in that person also as an accused. So the Supreme Court has said and reiterated, that is, the Supreme Court has reinstated again that while allowing an application under 319 of the CRPC, the test which is to be applied is more than just a prima facie case, which is experienced at the time of framing of charge. So standard should be above prima facie, but short of evidence that, if led unrebutted, would lead to conviction. So to be noted, during the charge framing, the standard is what? Prima facie case has to be met against those persons and charges are usually framed. But here for 319 CRPC, test to be applied is little more than the prima facie standard. The court also held that the discretionary powers under 319 CRPC should be used sparingly, which is it should not be used as a routine or a mechanical manner, and it should be used sparingly where the circumstances of the case warrant. The name of this case is N. Manogar versus the Inspector of Police. Next up, we have an update from the Delhi High Court. So the Delhi High Court has observed that a ration card, it is issued exclusively for obtaining essential commodities from shops under the PDS, which is the public distribution system. And these cards, the ration cards, they cannot be considered as proof of address or the proof of residence. The bench, it said that there is no mechanism set up by the authority which is issuing these cards to ensure that the holder is staying at the address which is mentioned in these cards. So therefore, they cannot be considered as proof of address or that of residence, and they are made just exclusively for the purpose of obtaining ration at the shops under the PDS system. The name of this case is Mohammed Hakim and another versus Delhi Development Authority, and this is coming from the Honorable High Court of Delhi. Moving on to the last update, which is also a Delhi High Court update, and this is in the realm of Arbitration and Conciliation Act. Section 29A petition maintainable if filed before award is delivered and not if the award is delivered. So before the award is delivered. The Delhi High Court single judge bench of Justice Prateek Jalan held that petition under Section 29A of the Arbitration and Conciliation Act, it is maintainable when filed before the arbitral award. It is delivered during the ongoing petition, but it becomes non-maintainable if it is filed after the award is delivered and the proceedings for setting aside have already commenced. So what is Section 29A? It was inserted via an amendment in 2015. It was meant to introduce time limit for completion of arbitration proceedings. It prescribes a statutory period of nearly 12 months, about a year, from the date the arbitral tribunal enters upon reference. So for the purpose of this decision, the court made a reference to this judgment. So the name of this case is National Skill Development Corporation versus Best First Step Education Private Limited and others. So that's all we have for today's TNA. Thank you for being with us. And in case you want to get access to the study material that we curate or the TNA slides that are used in this video, I would highly encourage all of you to join our Telegram channel. These are the point of contacts in case you want to get in touch with us. Thank you. Thank you so much for being with us.